Tech companies face a persistent dilemma. Hiring junior talent requires expensive, specialized training. But once that talent acquires those skills, they immediately become more valuable and routinely leverage their new resume to leave for higher-paying competitors. To counter this, employers rely on aggressive financial clawbacks. They insert clauses into employment contracts designed to impose a steep financial penalty on early departure, effectively locking junior employees in place. The legal check on these corporate tactics is a doctrine known as the restraint of trade. Historically, courts applied this doctrine to police explicit non-compete clauses, the terms that outright ban an individual from working for a rival company. Corporate drafters attempted to bypass this scrutiny by separating the financial penalty into a distinct training debt. The assumption was that a simple contractual agreement to repay a loan would avoid the stringent rules governing the restraint of trade. A 2026 ruling from the Court of Appeal closed this loophole. The court established that heavy financial anchors restrict mobility just as effectively as explicit bans, subjecting them to the exact same legal scrutiny. The case begins with Geeks Ltd., a software company that hired a defendant named Watts as a trainee quality assurance engineer. Upon hiring, Watts was required to sign two separate documents, a standard employment contract and a distinct training investment contract. This secondary document stipulated a training costs debt. If employment ended before working off the training value, Watts owed a direct repayment. He stayed for less than a year, resigning to join another company for a higher salary. 2 years after his resignation, Geeks Ltd. Brought an action against Watts to recover the entire sum of the training costs. Initially, the employer won. Both a deputy district judge and a circuit judge upheld the contract, ordering Watts to pay the debt. The case was elevated to the Court of Appeal. The judges there had to definitively resolve whether a separate debt clause could be struck down as a restraint of trade, putting the contract through a rigorous two-part test. The first pillar of the court's analysis asked a threshold question. Does the restraint of trade doctrine even apply to a debt repayment clause? Geeks LT argued that it did not. They maintained this was standard commercial debt recovery, completely distinct from a formal restriction on an employee's right to seek work elsewhere. The Court of Appeal rejected this defense. They ruled that the law evaluates the practical, real-world effect of a restriction, ignoring the superficial labels drafters assign to their documents. To anchor this, the judges pointed to a recent precedent, Steele v. Spencer Road LLP. This flowchart illustrates the precedent. Any clause requiring an employee to repay fees upon termination acts as an indirect restraint on trade. Applied to Watts, the looming threat of a large bill inherently restricted his mobility, engaging the doctrine across his employment documents. Companies cannot shield restrictive penalties by placing them inside separate debt agreements. If a clause financially punishes an employee for leaving, the courts will scrutinize it. Triggering the restraint of trade doctrine does not automatically render a contract illegal. It simply forces the agreement to pass a reasonableness test. The first half of this test places the burden on the employer to prove they have a legitimate, protectable business interest at stake. The court granted this point to Geeks Ltd. They assumed the company did possess a valid interest in maintaining a stable, well-trained workforce. But the second half of the test is where the scrutiny tightens. The specific contractual clause must go no further than is reasonably necessary to protect that specific interest. While the employer's end goal of retaining staff was valid, the aggressive, rigid execution of the clawback provisions was about to sail under appellate review. The court identified two fatal flaws in the contract. First, the clawback provision applied indiscriminately to almost every possible departure scenario. As this decision tree shows, the triggers were entirely rigid. The massive debt hit exactly the same whether he voluntarily resigned or was abruptly dismissed. Geeks Ltd. Could fire Watts on 1 week's notice. That single week still triggered immediate repayment of the full debt. The penalty also lacked sector specificity. It applied if Watts left for a direct tech competitor, but also if he left the industry entirely or decided to take no job at all. Against this sweeping application, the drafters included exactly one solitary exception: redundancy. Every other exit resulted in a bill. This blanket application is legally unreasonable. By universally punishing the employee, the clause acts as a blunt instrument against the worker, rather than a targeted protection against a competitor exploiting the company's training investment. The court's final analytical step was to pull back from the contract text and examine the broader economic reality of the agreement on the specific employee. During his time at the company, Watts was earning a salary just slightly above the national minimum wage. This chart demonstrates the harsh mathematical effect of the clawback. Subtracting the toggle training debt from his early month salary completely wiped out his baseline earnings. The court concluded this retrospectively reduced Watts to an unpaid intern burdened with a loan. This exact ratio proved fatal to the employer's case. Courts will not enforce business protections that economically devastate the restricted party upon their exit. The combination of indiscriminate triggers and devastating economic impact meant the clause went vastly beyond what was reasonably necessary, destroying its enforceability entirely. The Court of Appeal allowed the appeal, entirely striking down the repayment provisions and freeing Watts from the debt. For corporate counsel, the overarching lesson is clear. Rigid, one-size-fits-all financial clawbacks can no longer be utilized as a blunt tool to trap junior talent. Repayment clauses must have highly tailored triggers. Contracts must explicitly distinguish between a voluntary resignation to join a competitor and an employer-led dismissal. Drafters must also mathematically calculate the economic reality of the penalty against the employee's actual base compensation. The debt cannot retrospectively wipe out their earnings. Geeks Ltd v. Watts establishes a firm legal boundary. An employer's right to protect its financial investment ends the exact moment it destroys an employee's freedom to trade their labor.